I hope you'll turn up the volume. If you have a recorder, record the program, particularly this opening monologue, or at least you can go to marklevinshow.com and download it. Because in the context of what's going on today with these memos and the lawyers that Obama clearly wants prosecuted, I need to give a little history lesson. This is a history lesson I discuss in Men in Black, How the Supreme Court is Destroying America. And I quote author Craig Smith. During the Civil War, President Lincoln, now keep in mind Obama fancies himself to be Abraham Lincoln and Franklin Roosevelt. During the Civil War, President Lincoln suspended the writ of habeas corpus first in Maryland and then in southern Ohio because of its sympathy for slavery and states' rights and its geographic location. Reluctantly, Lincoln took the action against Maryland so he could prevent its legislature from meeting and voting for secession. In September of 1861, 9 members of the Maryland legislature were arrested. It was the first time a president of the United States had prevented a state legislature from meeting, and was a clear violation of their constitutional rights. However, the threat of the Civil War was so severe that Lincoln felt justified in his unprecedented action. The same would be true in Ohio. During his campaign for governor of Ohio, Congressman Clement L. Vallandigham gave a fiery speech in southern Ohio in support of the rebel effort. When General Burnside read reports of the speech in the newspaper, he had the congressman arrested and sent to Boston for trial. Lincoln eventually exiled the congressman to the South because he had some doubts about incarcerating a sitting congressman for delivering a political campaign speech. Then I explained Lincoln's suspension of the writ of habeas corpus was eventually challenged by John Merryman, a secessionist and citizen of Maryland. The case reached the Supreme Court of the United States, where the Chief Justice was Roger B. Taney, author of the 1857 Dred Scott decision upholding slavery. In Ex parte Merryman, Taney, writing for the court, held that only Congress could suspend the writ of habeas corpus. Lincoln ignored the Supreme Court. But in 1863, Congress passed a statute authorizing Lincoln to suspend the writ. Obviously, President Bush hasn't and didn't imprison or exile members of Congress or state legislators who oppose his handling of the war on terrorism. Indeed, he didn't take any actions to silence his critics. And the Bush administration detained only 2 U.S. citizens, and then only for overt acts of war against their country. Franklin Roosevelt. On February 19, 1942, during World War II, Franklin Roosevelt issued Executive Order 9066, which directed military commanders to designate areas, quote, from which any or all persons may be excluded, unquote. While the order didn't apply specifically to a particular ethnic group, its effect was clear. Tens of thousands of Japanese Americans and Americans of Japanese ancestry were systematically removed from their homes in western coastal regions and forced into internment camps. Not because of any evidence of criminal or disloyal behavior in particular cases, but because of their race. Now, President Bush didn't issue an edict rounding up, say, law-abiding Islamic and Arab Americans or Americans of Arab ancestry, forcing them into guarded camps where the government could watch over them. In fact, the Bush administration was loath to give special scrutiny to aliens who traveled to the United States from countries known to harbor or tolerate terrorists, including the home countries of the 9/11 terrorists. I'm giving you context so you understand just how preposterous these attacks on the Bush administration actually are. 1950. A case called Johnson versus Eisentrager, 1950. In Eisentrager, 21 German nationals, reading from Men in Black, were taken into custody in China at the conclusion of World War II. They were tried and convicted of war crimes by a U.S. military tribunal in China. They were then remitted to a military prison in Germany. They sought to bring their case to America by filing a writ of habeas corpus in the U.S. District Court for the District of Columbia. Sound familiar? The issue is whether alien combatants should have access to civilian courts. Justice Robert Jackson, writing for the Supreme Court's majority in 1950, was adamant in denying aliens this access. He wrote in part, quote, "We are cited to no instance where a court in this or any other country where the writ of habeas corpus is known has issued it on behalf of an alien enemy who, at no relevant time and in no stage of his captivity, has been within its territorial jurisdiction." Now you know why the Bush administration opened the Guantanamo Bay detention center and held the terrorists there. They were following the letter of the law as stated by the Supreme Court in the Eisentrager case in 1950. Justice Jackson realized the danger enemy combatants posed. He wrote, "But these prisoners were actual enemies, active in the hostile service of an enemy power. There's no fiction about their enmity. The German soldiers were denied the ability to petition civilian courts for review of their status. War limits the right of certain aliens to have access to U.S. courts, or at least it used to." Jackson wrote, quote, "It is war that exposes the relative vulnerability of the alien status. The security and protection enjoyed while the nation of his allegiance remain in amity with the United States are greatly impaired when his nation takes up arms against us. While his lot is far more humane and endurable than the experience of our citizens in some enemy lands, it is still not a happy one. But disabilities this country lays upon the alien who becomes also an enemy are imposed temporarily as an incident of war and not as an incidence of alienage." And he was talking about actual soldiers in war, POWs. We today are talking about terrorists. 54 years later, June 28, 2004, the Supreme Court hands down the decision in Rasul versus Bush, overturning the Eisentrager case, awarding itself jurisdiction not only over POWs, but over unlawful enemy combatants, terrorists, held overseas by the United States military at the command of the Commander-in-Chief. Not only reversing Eisentrager, the 1950 Supreme Court case, but all of American history. And Scalia, in his dissent, who was only joined by Thomas and Rehnquist, he said, "Today's opinion overrules Eisentrager and extends the habeas statute for the first time to aliens held beyond the sovereign territory of the United States and beyond the territorial jurisdiction of the courts. Today, the court springs a trap on the executive, subjecting Guantanamo Bay to the oversight of the federal courts, even though it has never before been thought to be within their jurisdiction, and thus making it a foolish place to have housed alien wartime detainees." His point being, well, hell, why do you think they opened Guantanamo Bay? Because they were following the supreme law of the land as issued by this court. And now we've changed our minds. We can't give a single legal basis for changing our minds, but now we have seized the authority of the executive branch, granted it to ourselves, and are exercising it without justification.